One of the questions that I often get is, at what age can a child, my son, my daughter, make their own decision about what parent that they want to live with? California law does not have an age at which a child can make any decision. If the parents cannot agree, ultimately the court has the authority, only the court has the authority to make that choice. However, at age 14, case law is clear that in order for the judge to make a decision, if the parents are in disagreement, the court must consider the wishes of the child and take into consideration how that child wants the matter to be dealt with. In my experience, often judges will consider children less than 14 years old. Usually at about 12 years old, judges will give some weight to the interest of the child. And in many cases, as a result of that, the court will appoint an attorney to represent the child, because without having a conduit, a way to get information from the child to the court, without the child having to sit in a witness stand in front of both parents and give information, it's a mechanism by which the court can get information from the child without the child feeling like he or she is being put on the spot in front of parents and being pressed to choose, which would be very emotionally damaging to the child. On rare occasions, a judge may actually talk with the child in chambers in private, and just have something more informal and be able to get information from the child in that way. Sometimes it's a challenge because even with older children, teenagers, maybe a situation where we have what I call a party parent versus a responsible parent. And, as you can guess, most teenagers don't want to live with the responsible parent. They want to be with party parent, where they can do what they want, stay out as late as they want, ingest any substance that they want, have any friends that they want, have really no rules. The parent is the friend parent. And so you can have a dynamic where you've got a teen saying, I don't want to live with responsible parent, I want to live with party parent. And the court's required to consider that. And the teen's not going to say this is the reason. The teen's going to give some other excuse or reason why they want to be with party parent. So there's just because a child does indicate to the court that he or she has a strong preference, and the court must give deference to that and weigh that, the court also has to be sensitive to what the foundation or the reason that this choice is that is being made. A significant role of attorneys in a situation like that is to be able to communicate to the court and separate for the court the reality of what's really going on in terms of the dynamics, so that information is being filtered to the court in a way that takes us back to what is in the best interest of this child. Is it really in the best interest of this child, despite their desire to be with party parent, to in fact be with party parent? Is that going to facilitate a child getting homework done, getting an education, getting ready for life as a successful adult? And so it's very critical that we have that information correctly communicated to the court.